Oh, welcome back. We'll take a look at your weather and sport this morning on the Easter Sunday edition of the South African Morning. Good to have you with us. The Justice Department is calling for comments on proposed amendments to the Promotion of Equality and the Prevention of Unfair Discrimination Act. Now, it's aiming to crack down on discrimination in the workplace. Under the law, companies will have to prove that they have taken reasonable steps to prevent discrimination by employees. Now, if they fail to do so, they will face legal action alongside their employees. Now, to discuss this, let's unpack what is a very complicated part of labour law. Luckily, we have a labour law specialist, Magata Phale, who is joining us. Magata, good morning to you. It is very complicated, isn't it, when it comes to companies, employers and employees? This discussion, from what I can read, and I'm by no means a lawyer, seems to be the company having to prove that they've done everything they can to prevent discrimination. And the fact we're having this discussion means that most companies probably aren't getting this right, are they?
Yes, good morning, Gareth, and to your viewers at home, and thanks for having me on your show. Yes, indeed, but I must also just indicate that these new amendments of PEPUDA, or Prevention of or Promotion of Equality and Prevention of Unfair Discrimination Act, it's in addition, I mean, speaking from the context of workplace, it's in addition to what we already had in terms of the Employment Equity Act of 55 of 1998. And I'm glad that these new amendments have actually widened or broadened the scope of this piece of legislation, because this legislation aims to fight unfair discrimination on the basis of listed grounds: age, sex, gender, sexual orientation, and the emphasis now is actually put on people living with disability as well. So, in terms of what you've just said earlier, that companies or employers will now have to prove that they took reasonable steps to try and address any complaint of unfair discrimination by employees. It is actually something that our courts, as final arbiters on interpretation and application of the law, have actually decided in the past when it comes to, and I know sexual harassment is also a topic on its own, but if you speak about or within the context of Employment Equity Act, sexual harassment has also been defined as a form of unfair discrimination.
Magata, help me understand, because I think you're absolutely correct in how they're going to have to now adapt to these new regulations. I just wanted your thoughts on this. Whenever it comes to reasonable steps in a legal application, there's also the of law of reasonableness and all that. It's always a bit more of a grey area, isn't it, when it comes to what is reasonable steps in a case like this. So help an employer watching this understand what is considered reasonable in this case.
Okay, what the new amendments require is that, as an employer, say for instance, an employee brings to the attention of the company that there's been an act of unfair discrimination, maybe by one of the managers or by the company itself or by a fellow employee. And the company should, when we say reasonable steps, should actually make attempts to try and resolve that particular complaint or grievance. And there must be a record of that. So, in other words, internally within the company, those measures should all be exhausted to prove that indeed the company or the employer did not just shut the employee out, or did not just say we will not attend this, or they just ignored the employee's grievances or complaints in that regard. But the act or these new amendments take it even step further to say, especially the emphasis is being put on people living on with disability. that you need to, as an employer or a company, need to put measures in place, that will, sort of reasonably accommodate those people or those employees who live with, disabilities. For instance, I will just give you an example. I mean, you have seen in some employers' buildings or premises that, they are required to have, easy access for people living with disability, or any other facility that will make these people or these employees who live with disability to be fully functional as if they were not living with those disabilities.
I appreciate your time in speaking to us. There's a lot to actually take into account. I think most people would have thought that these reasonable steps were in place, but clearly this new draft law suggesting it's not actually the case. So employers need to be a lot more careful in how they handle acts of discrimination between employees and between employees and employers. Magata, I'm going to say thank you very much indeed. I know there's a lot more involved, obviously, when it comes to labour law, but I think we got the gist of it from labour law specialist Magata Phale.